It's an important one because we can't have government agencies regulating unsettled aspects of our political and religious discourse, right? Like this, right? This is not something that everybody agrees on, and there are a few crazy people who refuse to use gender pronouns. Like this is a topic that is still being very much debated in our culture and in our politics. And for schools to just come in and say, no, you must take this side, huge problem. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. An interesting lineup of topics here today. We're going to start by covering a RLUIPA claim, that's Religious Land Use and Institutionalized Persons Act, which is a kind of companion federal law to the Religious Freedom Restoration Act. And this is a claim brought by a Rastafarian prisoner. Then we're going to go to the Sixth Circuit and we'll talk about a ruling regarding an Ohio school district's policy that essentially compels speech by punishing misgendering in the school. And then we'll wrap up by briefly mentioning the U.S. Supreme Court's decision not to hear an appeal by former Kentucky County Clerk Kim Davis, who now it's been forgotten, but she was a big deal in the news post Obergefell. So this now decade-old issue has resurfaced, and there was an attempt to, among other things, overrule the Obergefell gay marriage decision, which was cert was denied, and that is the end of that. So let's start with the RLUIPA claim. So it's an interesting case, and it's one of these ones that I always like to cover either on the podcast or in publishing, because what ends up making the headline is a big, religious liberty or controversial kind of claim that is actually not what's legally at issue. And this is a perfect case of that, I think. I'll be interested to hear you weigh in on this, Joseph, after I lay out some of the arguments as I see them. So the issue here is the claimant, his name is Damon Landor. He's a Rastafarian who has apparently practiced as part of his Rastafarian religious beliefs that he takes the Nazarite vow, which I learned something researching for this. I didn't realize that Rastafarians did this and that was the connection to the long dreadlocks. I know most Christians are probably familiar with this as an Old Testament, right? The Nazarite vow of certain prophets who would vow not to do certain things, including let a razor touch their head and they would grow their hair out. So anyway, Damon Landor has taken this vow for a long time as part of his faith for decades. He's let the locks of the hair of his head grow. That's the quote from the Book of Numbers. So Landor was imprisoned with a 5-month prison sentence, received a religious accommodation to keep his dreadlocks. I think he had an order or had the precedential opinion from the Fifth Circuit on this issue with him. So it was respected for the majority of his imprisonment. He kept his dreadlocks. He was transferred to a new correctional facility and explained his accommodation, where very dramatically, this almost seems more like the stuff of like a TV or movie scenario. It was pretty shocking. The prison officials apparently took the documentation that he gave of his religious accommodation, threw it in the trash, strapped him down, and shaved his head. So Landor understandably sued the officials in their personal capacity using RLUIPA, which is, again, the Religious Land Use and Institutionalized Persons Act, provides religious protections both in land use by for religious purposes and also for institutionalized persons, which is generally prisoners. So this is, it was an interesting case. It went up to the U.S. Supreme Court. Oral arguments happened, I think it was last week by the time this is published. And so there's some interesting stuff going on, both in what was briefed and in, I think, some of the hints that were made at the oral argument. So the central claim is not whether the inmates' religious rights under RLUIPA were violated. It seems pretty obvious to everybody that they were, and shockingly so. So that's actually not what is at issue. It's not whether a Rastafarian has a right to grow his dreadlocks out and get a religious accommodation when he's in prison. The answer to that, it seems pretty clear. The question centers around the statutory interpretation and the implementation of RLUIPA, and I think it's worth just spending a couple of minutes on this. So what's basically going on is, well, two things. There's kind of a side claim that I won't focus on about whether prison guards in this case, the people who were sued in their personal capacity under RLUIPA, are actually in a place to be personally held liable under RLUIPA because they're not actually party to the federal contract. There's a contract between the prison and the government, and these people were, probably not aware of the federal implications of RLUIPA or of their involvement, and they're not a direct party to the contract. So I didn't go as much into that issue because I think the other one is what took most of the Supreme Court justices' time and is of most interest to me, which is just the baseline question of whether RLUIPA authorizes money damages against individual defendants. That seems to be what was at issue, and I think is what will probably decide this case, given what we saw at the oral arguments. So again, everyone agrees that Landor did have an order from the Fifth Circuit that he should have had a religious accommodation. It should have been respected when he was transferred into this new prison. And everyone also seems to agree that the behavior of the prison guards was egregious and unlawful. So what's going on here? What's going on here is that it's not clear what relief is appropriate when you sue someone in their individual capacity who's working on behalf of the government under RLUIPA. So the relevant line in the RLUIPA statute says, a person may assert a violation of this chapter as a claim, as it is here, or a defense, in a judicial proceeding and obtain appropriate relief against a government. So the argument centers on what is appropriate relief, right? Is it clear to government employees in their personal capacity that they could be sued for monetary damages for violating RLUIPA? There was a lot of interesting back and forth at oral argument here, and I think both sides were pretty passionate about this question, right? So Landor's attorney at the oral argument was pretty vigorous about this, saying, listen, the result is obvious. And it's a good rhetorical argument, but I don't think it holds up under legal precedent. And what the attorney's saying here is, listen, there's clearly a right. Everyone's acknowledged that there's a religious right here. And it was egregiously violated. So if there's no proper remedy, it's a meaningless right. I'm paraphrasing, but that was the gist of the argument, right? What the lawyer is saying is, here, if you get an order and it says, these prison guards cannot shave Landor's head under RLUIPA, he just gets transferred, right? They can transfer him to another prison, and before there's another lawsuit or another accommodation, the new prison guards who haven't been made aware of this, they just do it anyway, and there's no order and there's no real consequence. What do you do if you can't get money damages out of the prison guards who are violating these rights? There's nothing here, right? It's a toothless right, and they can just kind of trample on religious rights, and there's nothing anyone's going to do about it. So basically, it's an argument that without the remedy, the right falls apart, right? There's no way to actually enforce it. The justices seem skeptical. Again, everybody during oral argument seemed to agree, like, this is a pretty egregious violation, but we have a problem. There are a couple of problems that were articulated. One was Justice Gorsuch and I think Alito were very skeptical about, first of all, the claim that it was obvious, right? Because the lawyer here is saying, well, this is obvious that there are monetary damages allowed, because how else would you enforce the right? And I think it was Justice Alito who pointed out that, listen, in the Tanzan case, which is a similar case about money damages under RFRA, which did allow money damages in RFRA, it seems that there was dicta, or there was an indication in the Tanzan case that there's a distinction for RLUIPA and that money damages may not be allowed because of the way in which RLUIPA came to be as opposed to RFRA. Anyway, it's a technical question of law, but I think it was Alito, forgive me if I'm wrong on that, but who said, you can't really argue in good faith that it's obvious that monetary damages are allowed when we have, Supreme Court dicta saying that they're probably not allowed. So it's clearly not obvious. And then further, there was a lot of talk about, you need a clear indication to, in this case, the government officials, that if they're going to be sued in their personal capacity, that they need to know, what they can expect, right? If they're potentially running afoul of RLUIPA, it should be clear that they're subject to money damages if they're being sued, because there are sovereign immunity issues, right? You're suing people who are part of the government that has a good deal of immunity in the way that they do a lot of their work. So there was a real question here about, well, we want it to be clear from the statute or clear from the precedent that people who are acting as state actors are actually subject to money damages in their personal capacity and not protected by any kind of governmental immunity before we're going to say that, yeah, you can sue them for money. And it was an interesting back and forth, because I think Well, a couple of things. I think for one, it's been pointed out by some of the other justices in this argument that, hey, government actors get sued under Section 1983 for constitutional violations all the time, and it's not out of the it's not just like out of left field, and they're shocked that they've been hit with lawsuits that involve money damages when they're violating someone's constitutional rights. Is it really such a stretch to apply that to RLUIPA and say, hey, you know that prisoners have rights, you know that RLUIPA is a federal statute that governs prisoner conduct, and when prison guards are going to, in this case, pretty blatantly disregard a religious accommodation, then it shouldn't be so shocking that they get hit with monetary damage claims. Again, I think we never like to predict outcomes of cases based on oral arguments, but I think if there's any indication from this oral argument, it doesn't look like the Supreme Court is going to rule in Landor's favor here, at least not to me. So I think there's a strong legal argument to support this outcome, that you want to be very careful before putting government actors in danger of being sued in their personal capacity for money damages when they're carrying out government business. But at the same time, it is troubling to me, just as a matter of policy and the enforcement of rights, to see a situation where, all right, something's wrong, right? If obviously everyone agrees that there's a grievous violation of a religious right, and there's really nothing that's going to discourage government actors from violating that right, it's troubling. So I'm not saying that it would be the wrong legal result, but there's something to ponder there. And as the lawyers on the other side, I believe, said in this oral argument, they said, listen, there's a solution. And it was pretty clever. He said, but the solution is not in this building, it's across the street, right? Not at the Supreme Court, but at Capitol Hill. That, yeah, this is a statutory right under RLUIPA. And if there should be a statutory remedy to money damages if people violate this, that's fine. It should be a bill passed by Congress. RLUIPA should be amended to specifically say money damages are on the table if people are egregiously violating these rights. That seems reasonable to me. But Joseph, I'd love to hear more from you. I've talked enough on this issue.
Yeah, thanks so much for kind of giving the rundown. And like you said, you'll see the headlines about, oh, Rastafarian inmate gets his religious freedom. That's what's on the table. It does get a little more nuanced. So I'm always happy when we're able to bring a little bit of clarity into what's actually going on here. I know we did that recently with the whole Johnson Amendment issue a few weeks back. So anybody interested in that, check it out. But I do want to zoom in a little bit on, you mentioned that Tanzan case. And I'm interested in and curious to see how the court is actually going to use that case here, because it did come up in oral arguments and some of the logic is pretty similar. But there are, like you said, important distinctions. So in Tanzan, this was a case back in 2020 where a group of Muslim men were placed on a no-fly list. They claimed that it was retaliation for refusing to inform on other members of their community. In response, they sued members of the Department of Homeland Security in their personal capacity, and they sued under RFRA. And like you mentioned, that's the sister statute to RLUIPA. Now, regarding remedies, both of these statutes have the same language. It's obtain appropriate relief against a government. In Tanzan, SCOTUS held 8-0 as unanimous. Justice Barrett recused herself, but all the justices that actually voted held 8-0 that RFRA's appropriate remedies language does indeed enable this monetary damage. But like you mentioned, there is that big difference in how these statutes came about and who it's actually being applied to. In the RFRA one, it was federal officials. In this one, it's a state level official. So there's some sovereign immunity questions. And like you mentioned, kind of where RFRA comes from as opposed to where RLUIPA comes from. But reading through Tanzan, that only gets about a paragraph of explanation. So even if they do apply the same logic and say, sure, the language is the same, but because it's a different person, this is a state official as opposed to federal, I am interested in seeing if that logic gets fleshed out a little bit more so that moving forward, we're able to understand more of what this appropriate remedies language mean and more of what it means when it's applied to different types of officials. So like you said, lots going on here, a little bit more nuance than some of the headlines will look like, and we'll certainly continue tracking this one as we get closer to an opinion in spring or summer. So do you have anything else to add?
Now let's move on to the Sixth Circuit. There's a lot to cover in this next case too.
Yeah, great. So moving right forward into the Sixth Circuit, we're going to talk about a recent en banc case where the circuit ruled against a public school district's what's painted as a compelled speech policy. So we're going to take a little bit of a walkthrough on what laws and what Supreme Court precedents impact when a public school can regulate speech. the facts of this case are pretty straightforward. So, and this is the first time we've covered something exactly like this. So we're going to get a little bit into the legal analysis here. But starting off with the facts, like I said, they're pretty straightforward. This Ohio public school district called Olentangy Local School District, they have an anti-harassment or a bullying policy that effectively served as a compelled speech requirement. Some parents asked the leadership about it, and per the district leadership, quote, a student purposefully referring to another student by using gendered language that they know is contrary to the other student's identity would be an example of discrimination under the policy. So basically, if there's one student who is a boy and says, oh, I want to go by they, them pronouns. If another student calls that student him, under this policy, that would be harassment, bullying, discrimination, and they'd be subject to really whatever penalty the school saw fit. So parents of students that were afraid to use the pronouns that they believed to be accurate filed a lawsuit. They're all anonymous, so it's the person bringing this case is a group called Defending Ed. They're a nonprofit centered around basically non-political education. And there's some fuzziness in the actual policy, but the school did acknowledge that this policy would require students to use pronouns that they may disagree with based on their religious beliefs. So, like I said, this case was recently heard and decided in the Sixth Circuit en banc. It ultimately did go in favor of Defending Ed and against the school policy that was effectively compelling speech. And like I mentioned, this is the first time we're covering a case involving regulation in a public school quite like this. So we're going to walk through a little bit of the cases that came up in this decision. And the most impactful here is Tinker from 1969. So in Tinker, the court basically decided that students don't forfeit free speech when they enter the schoolhouse at a public school. But at the same time, schools also have a greater capacity to control speech within their walls and within their students than is typical because basically this is because the schools are acting in loco parentis, which means in the place of parents, by supervising students during the school day. They're assuming some of the disciplinary responsibilities that parents have. Now, this doesn't mean that schools then are the parents. It's not instead of parents, it's in the place of. So they just assume some of the responsibilities that parents typically have, but the kids are at school, so the parents aren't there. So where is this balance drawn between schools have the right to regulate speech, at least a little bit, at the same time, students still have the capacity and the right to speak freely? So in Tinker, the test that came out of it is that schools cannot restrict personal speech unless the speech is, this is pulling directly from the decision, the speech substantially interferes with the work of the school or impinges upon the rights of other students. So if speech either substantially interferes with school activities or impinges upon the rights of others, then public schools have a little bit more leeway to regulate that. Now, there are some caveats to that in a few different pretty big cases. Starting off in this one called Hazelwood, the court ruled that public schools have a greater capacity to regulate speech if that speech is part of curriculum. So if the speech kind of has nothing to do with actually what's going on at the school, if it's not the school-sponsored speech or the school's curriculum, there's not as much wiggle room there. But like a teacher can give a failing grade if a student gives a wrong answer. They can't say, well, free speech, I can say what I want. It's part of the curriculum. There's a little bit more leeway there. Similarly, in two other cases, Frazier and Morse, a little bit more power was given to schools to regulate speech if it's indecent or lewd and it's on school grounds. That was Frazier and Morse. You can also regulate language that encourages drug use. That was kind of an interesting case that was going on there. So anybody that's looking for kind of a fun fact pattern, I encourage you to read it. And then lastly, in this one called Barnett, basically they said that public schools can't set or prescribe what's the norm for politics, religion, or opinion, and thus compel speech in those categories. So those are the four cases that kind of led the opinion in this one plus Tinker. So applying all these different things here, the speech being regulated here is forcing students to use pronouns that they disagree with. So we'll kind of go through those caveats first. It's not lewd or indecent, so that doesn't give the school more room to regulate it. It doesn't encourage drug use. The regulation then isn't permitted by Morse as well. It's definitely not part of the school's curriculum. That's what Hazelwood would cover. And then kind of in support of ruling against the school, and Barnett makes it clear that the school can't say, wait, this is part of our curriculum, and then regulate it. This is a topic that's rooted in a student's faith and in, to some people, opinion. So they can't just say, wait a minute, we're going to regulate it. You can't say it's part of your curriculum. And then taking all that, so it passes all the caveats. Now does this, how does Tinker apply? So A, does it substantially interfere with school activities? Or B, does it impinge upon the rights of others? And these are both pretty high standards. It's not easy to prove that speech that's being regulated did either of these things. And the court put the burden upon the district um, in this case, and they said the school failed to show that using these pronouns other than those requested by another student, it doesn't violate anybody's rights and it doesn't substantially interfere with school activities. The district failed to show that. So because of that, this is likely unconstitutional regulation of a protected speech via viewpoint discrimination. Because of that, the circuit ruled in favor of defending Ed and the parents and gave a preliminary injunction. So there's kind of the walkthrough of how to regulate speech in public schools and when you can and cannot. So anybody that's an expert on this, we would love to have you on. But since we haven't really covered something quite like this, we wanted to give kind of a substantive walkthrough. And Frank, as our local expert on public schools and their history, I'd love to hear what you have to say here.
Yeah, to me, I mean, this one is it's pretty straightforward. I won't just give the common sense view that I want to, but we'll just talk about a couple of the precedents here, right? So just to summarize, what I think is really at issue here is you have the Tinker standard, and the part of the Tinker test that is relevant here, right, is the impinging upon the rights of others. That's the only way that I think you would get this through, because I mean, you know, students calling somebody he, him instead of they, them doesn't substantially interfere with the work of the school. That's beyond a stretch. That's kind of silly. So the question is, right, does this impinge upon the right of a student? And first of all, you have the question of does it, like, do you have a right to be called by certain pronouns that are different from your actual sex based on whatever your preferences, your identity, your personal beliefs about yourself? I mean, I think you'd have a hard time arguing that this is somehow a right to have people talk about you in a certain way. And then you also have the question that we brought up before, but this isn't even about, like, you could have the better case for this is, you know, students using this kind of language to harass each other. If you were talking about interaction between the student who's getting in trouble and the student who is identifying as some other gender or what have you, right? But pronouns are by definition third person in these cases. He, him, they, them. You know, it's not when I address you, I address you by your name, or I say you, right? So if I'm saying, oh, he, him instead of they, them, I'm by definition talking about this person to somebody else. They're not even there. So the idea that they're being harassed like indirectly when they're not even there, it's silly, to be frank. So I don't think there's any serious argument that this could rise to the level of something that's so seriously impinging upon the rights of some student that the government can come in and regulate speech. There's no reason for it. It's not seriously interfering with the work of the school. And then you have what you had pointed out, Joseph, is this precedent in Barnett, which is a really important thing to just kind of put a fine point on it, that schools can't set prescriptions of what's the norm for political religious opinions, right? This is all, I understand that schools regulate the speech and the conduct of minors, so there's a little bit of a different standard than, you know, free speech for adults in the public square, sure. But the First Amendment principle when you're talking speech is always that when we're talking about a particular viewpoint on politics or religion, especially, that's when First Amendment protections are at their highest. And that is what's going on here, right? This isn't just a case of, you know, people saying something lewd or outlandish or encouraging deviant behavior. This is a political opinion to say, like, no, actually, the pronouns that you use about a person, regardless of what they think they are, correspond with their sex, with the truth of who that person is. That's a religious and or a political belief. And so for the school to come in and say, well, no, you don't have a choice, you have to refer to people by these pronouns only and not these other ones, to me, that's where First Amendment scrutiny should be at its highest, because you're trying to impose a particular viewpoint on your students that, again, doesn't implicate harassment or indecency or anything else that the school has like a serious interest in enforcing. So maybe long story short, I think this is where First Amendment protection is at its highest, and the school's argument is pretty bad. So the preliminary injunction makes sense. My guess is that when this is eventually decided on the merits, it will go the same way. And it's an important one because we can't have government agencies regulating unsettled aspects of our political and religious discourse, right? Like this, right? This is not something that everybody agrees on, and there are a few crazy people who refuse to use gender pronouns. Like this is a topic that is still being very much debated in our culture and in our politics. And for schools to just come in and say, no, you must take this side, huge problem. So glad to see this injunction, and hopefully we'll keep following this, but my guess is that it will go the same way ultimately. All right. I know we've spent a lot of time on the first two cases, so we'll just spend a couple on this last one because honestly, I don't think there's that much to say. As much as another one that got a lot of headlines, but I think was, I don't want to say much ado about nothing, but a little bit much ado about nothing. And this was Kim Davis's challenge asking the Supreme Court, among other things, to overrule the Obergefell v. Hodges case, which, as you all know, was the case that allegedly declares same-sex marriage a constitutional right under the 14th Amendment. So what was going on here? Well, first of all, you'll see the headlines. They're everywhere. Supreme Court refuses to overrule Obergefell. Love is still love. These are real headlines. There's all kinds of celebrations that, oh, good, the Supreme Court is not going to touch this sacred ruling of Obergefell v. Hodges. My reading of what happened in this case, as well as a lot of the really good legal commentators who I tend to trust on this, was that this really wasn't about the Supreme Court definitively saying Obergefell is settled. This was just kind of a bad case. So what happened? So Kim Davis, she was the county clerk who was the first one who kind of made headlines after Obergefell because she wouldn't issue same-sex couples marriage licenses from the county clerk's office in Kentucky where she was working. So as a result, she was actually jailed over her refusal to, because she didn't resign. She just refused to give the marriage licenses. She was subject to a lot of to heavy damages, including attorney's fees. There was a whole big falling out from her refusal to issue these licenses. And you can think what you want about whether she was right to fight or whether she should have resigned. It's a good question. But in her appeal here, what happened was a couple that was denied a license sued her for emotional distress, right? There was no actual monetary damage, no physical damage. They were emotionally distressed for being denied a marriage license by Kim Davis. And so this was the case that was appealed up and petitioned for cert at the Supreme Court here. And there are a couple things being argued, but I think it's worth pointing out what they are. So there were three questions presented to the court that the court denied to hear. So most of them center not on Obergefell itself, but on whether Kim Davis's First Amendment right to free exercise of religion should be an affirmative defense to the tort liability for emotional distress, right? So they claim you caused emotional distress. Should she have a defense that, well, I was exercising my First Amendment right to free exercise? There's some precedent that in similar cases when you're expressing free speech, there are some defenses to emotional distress claims. Then there's another argument about when Kim Davis was stripped of her immunity as a government employee and sued in her individual capacity, whether she should have these First Amendment defenses. And these are interesting questions, right? Because on one hand, it's like, well, if she's exercising a constitutional right, shouldn't that be something of a defense to being sued for, emotionally distressing somebody, which makes sense. There have been some interesting responses to that. There's a scholar at Heritage Foundation named Thomas Jipping, who we know here, who made the point that, well, she wasn't acting in her personal capacity. She was acting as a state actor. And so your free exercise rights are not quite the same when you're not acting as a private citizen, but as a part of the government. So maybe not the best case. And then just if you're stripped of your immunity rights, does that mean that you were actually acting in your personal capacity and have the First Amendment defenses? Don't think it works like that. So they're interesting questions, right? But then the third question that was presented in this cert petition that was denied is whether Obergefell v. Hodges and the legal fiction of substantive due process should be overturned. Now, I think even people, which I would include myself, the answer to that is yes. Substantive due process is in fact a legal fiction. It should be overruled. So should Obergefell v. Hodges because it's a lawless decision that's based on a policy choice. And not the Constitution under any sane reading of what it means under either natural law or originalism. So the point, though, is that this is a bad vehicle for this. It's questionable why the court would want to take up a case that involves Kim Davis exercising her free exercise rights and whether that's a defense to tort liability based on emotional distress. It's just not a good vehicle to take on Obergefell head on. That being said, my guess is that this court is probably not ready to or interested in overruling Obergefell at this point anyway. If I had to guess, that's just, court whispering guesswork. But even if they were, this just doesn't seem like the case they would take. There are a lot of bad facts. Obergefell's constitutionality itself is not, in my mind, the primary issue here. So I know a lot of people were celebrating that this is a great, affirmation of Obergefell and same-sex marriage and under constitutional law and so forth. But I never really thought that this was going to get taken up and that this was going to be the vehicle to overrule Obergefell. If there was even any appetite to do so in the first place, I don't think it would be with this case. So that's about all I have to say on that. Joseph, do you have any additions before we wrap up?
Yeah, not too much. Really, like you said, this was, I think, for people that were following this case closely, that are really familiar with what's going on legally here. I don't think this comes as much of a surprise. I will say it garnered a very small amount of attention from the court. I think it requires one justice to request a reply brief from the respondent. That happened, but even when that happened, it really never had a whole lot of attention being brought before the court. So, not super surprising. I think you really covered what's going on here pretty well.
Well, thank you. Yep, no more need to go on about that one. I think we've covered the first two cases in a lot of detail. This one is a non-issue and is the end of this conversation in any event. So I think we will wrap up. Thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you would like and subscribe to our channel on YouTube, Spotify, or wherever you're listening from. If you want to support the work of this podcast and the Napa Legal Institute in general, we always appreciate your support. You can go to napalegalinstitute.org and contribute to the work that we're doing. So we hope you'll join us next week as we continue to highlight and discuss some of the most important legal questions that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.